The moment the word divorce enters a marriage, a parallel and spoken process often begins, the safeguarding of finances. It's a reality driven by fear, uncertainty, and the desire for self-preservation, but this is the most legally perilous financial crossroad you may ever face. Every move you make with your money will be scrutinized under a judicial microscope. The line between smart, legal asset protection and fraudulent concealment is razor thin, and crossing it can destroy your credibility, result in severe financial penalties, and even land you in contempt of court. So, how do you navigate this? The answer isn't in last-minute tricks or offshore shell games. True, effective asset protection in divorce is built onto pillars: long-term, proactive planning done long before any trouble rises, and scrupulously legal, transparent conduct during the proceedings itself. Today, we're going to walk through both. We'll start with the gold standard of premarital planning, move through the critical documentation that protects what's rightfully yours, outline the ethical rules of engagement during the divorce process, and introduce you to the key professionals who can be your guides. This is a roadmap for preserving your financial integrity and your assets through one of life's most challenging transitions. The single most powerful tool for asset protection is one implemented long before any thought of divorce: the prenuptial agreement. A well-drafted prenup is not a prediction of failure, it's a blueprint for clarity. It allows both parties to define, in advance, what constitutes separate property assets owned before marriage, future inheritances, family gifts, and to waive or limit claims to that property upon divorce. It can outline how marital property will be divided, potentially avoiding costly litigation for business owners. It is indispensable for shielding company equity acquired before the marriage. The key to a prenup's enforceability is full financial disclosure from both parties and each having their own independent legal counsel. A prenup signed under duress or without disclosure can be thrown out. If you're already married without one, a postnuptial agreement can serve a similar purpose, though courts may scrutinize it even more closely for signs of coercion. Think of these documents not as weapons, but as the ultimate form of financial transparency and mutual understanding. When divorce becomes imminent, your first and most important task is documentation and inventory. You must know exactly what you have before you can protect it. This is not about hiding. It's about proving. Begin a meticulous inventory for assets you claim as separate property. You must have a paper trail. This means gathering deeds or titles from before the marriage, bank statements showing the premarital balance, records of inheritances with probate documents, and family gift letters stating the intent is for you alone. The danger is commingling. If you deposit a $50,000 inheritance into a joint checking account used for mortgage payments and groceries, it likely transforms into marital property. To protect separate property, keep it in accounts solely in your name and do not use it for marital expenses. For marital assets, you also need a full record, recent statements for all joint and individual accounts, retirement plans, investment portfolios, real estate appraisals, and business valuations. This documentation serves two purposes. It ensures you get your fair share of marital assets, and it provides a baseline to detect if your spouse is improperly dissipating assets. Now, we enter the operational phase, governed by one iron rule: transparency and ethical conduct. Once divorce proceedings are underway, or even when you reasonably anticipate them, you are under a fiduciary duty of disclosure. What does this mean in practice? You must not: 1. Hide assets in secret accounts or transfer them to friends, family. 2. Inflate debts or expenses. 3. Make unusual large cash withdrawals. 4. Deliberately devalue assets like selling a car to a cousin for $1. 5. Rush to drain joint accounts. These actions constitute fraudulent dissipation of assets. Courts have immense power to punish this. They can award the wronged spouse a larger share, order the hidden assets turned over entirely, and impose sanctions. Instead, your conduct should be above reproach. Maintain normal spending patterns for reasonable expenses. If you need to use marital funds for legitimate needs like retaining an attorney, document it clearly and be prepared to justify it. This ethical high ground is your strongest legal position. This is where your professional team becomes critical. You need advocates who can operate within the rules to achieve the best outcome. Your divorce attorney is your strategist and legal shield. They will advise on what motions to file, such as a temporary restraining order that automatically prohibits both parties from selling, transferring, or borrowing against marital assets without consent. They will handle the formal discovery process to ensure full disclosure from your spouse. A forensic accountant is your financial detective. If you suspect hidden income or assets, offshore accounts, unreported business cash, undervalued stock options, they have the skills to follow the money. They are also essential for valuing private business interests, a common area of dispute. Consider mediation or collaborative divorce as alternatives to litigation. These processes can be less adversarial, give you more control over the outcome, and are often faster and cheaper, which in itself preserves assets from being drained by legal fees. Finally, strategic thinking about specific asset classes can make a significant difference. For the marital home, emotions run high. Consider whether keeping it is financially prudent after accounting for mortgage, taxes, and upkeep. Sometimes, selling and splitting the equity provides cleaner financial independence. For retirement accounts, remember they are often the largest marital asset after the home. Dividing them requires a QDR, qualified domestic relations order. Ensure this is drafted correctly to avoid unintended tax penalties. If you own a business, its valuation is the key battleground. Hire a business valuation expert, not just your company's CPA. Be prepared for your spouse to claim they contributed to its growth. Documentation of their actual involvement or lack thereof is crucial. In conclusion, protecting assets in divorce is a marathon of preparation and principled conduct, not a sprint of deception. It begins with a prenuptial agreement, is sustained by meticulous documentation that clearly separates property, and is executed with unwavering transparency during proceedings. Your greatest assets in this process are a skilled attorney, a clear paper trail, and your own ethical discipline. Critical legal disclaimer: this video is for educational and informational purposes only. It is not legal or financial advice. Divorce and family law are intensely fact-specific and vary by jurisdiction. The strategies mentioned are general concepts. Hiding assets, fraudulent transfers, or violating court orders are illegal and will have severe consequences. You must consult with a qualified family law attorney in your area to get advice tailored to your specific situation before taking any action. Navigating a divorce with your financial future intact is challenging, but with the right knowledge and the right team, it is possible. If this guide provided a framework for thinking about asset protection, please subscribe. Let me know in the comments which asset class you think is the most challenging to protect during a divorce.